The judge said, well, now you're in contempt, but you can cure the contempt by complying with my illegal vacated TROs that he had no power to order at all. So he's almost in direct contravention of the Supreme Court and saying you can purge that contempt, right, by complying, by just doing what I said. Well, I didn't have to do what you said. It was illegal. Well, do it. And you'll purge your contempt. And the Supreme Court is just sitting there, just allowing this to happen. Like, The AEA disallows for relief for covered enemy aliens. You cannot invoke withholding of removal when you're a terrorist. Sorry, we give it to good people, not terrorists. The Trump DOJ striking back against Judge Boasberg and the gangbanger lawyers. You see, this is the case out of Washington, D.C., the District of Columbia, involving JGG. And this is Judge Boasberg, the same judge who said, Trump, turn those airplanes around. He was flying all these people out to El Salvador. He said, literally, turn them around. Trump didn't do that. The judge said, why not? He said, because you don't control us. You're not the president. And the judge ultimately had his jurisdiction, in my opinion, stripped from him by the Supreme Court of the United States. They said, you can't have this case heard here. They need to bring it in Texas in a petition for a writ of habeas corpus. So you can't hear it, but the judge kept the case, invoked contempt powers, and said that gives him control of the proceedings moving forward. And under that made up contempt power, he doesn't have contempt. You can't hold someone in contempt for an illegal order against a co-equal branch of government. The case law does not support that effort, even though he says it does. But with all of that happening, he's now considering a second injunction under the contempt powers. So if it's like you're creating an outline, it's just nestled into all these different powers, but the first chain is cut off. Now here is Trump's response to the request for a second injunction after the Supreme Court said the original injunction was invalid. All right, this is the gangbang lawyers' second attempt to challenge President Trump's invocation of the Alien Enemies Act with respect to Tren de Aragua in America. And this is happening in a district in which none of the affected individuals are located. Washington, D.C. The gangbangers are not even here. They're citing footnote 1, and they're going to say, okay, they're just telling us who's who. Now, the Supreme Court decisively rejected the first attempt, and you can look that up. And the second one should meet the same fate as well. The fact that we're even in here is joke and a scam. I mean, it's really an insult to the Supreme Court, who said, you don't have power over this. He found another exception to say, yes, I do. Now, the president properly designated members of Tren de Aragua as alien enemies in his proclamation. And as a result, the government has been steadfastly attempting to remove them while fully complying with the law. Now, these people, the gangbang lawyers, have responded by attempting to disrupt the lawful process by throwing theories at the wall to see what sticks. And unsatisfied with the Supreme Court's rejection of their first line theories, the first injunction was vacated, the gangbang lawyers have concocted two new innovations to establish jurisdiction in this court. Made it up. First, they claimed that some respondent in this district, someone, must have constructive custody over the aliens removed to El Salvador. In other words, somebody in DC, Rubio, Trump, Noem, Bondi, somebody has power. And they don't know who exactly or how it works exactly, but they're in DC, somebody's in DC, Washington's here, Congress is here, it's all here. So somebody's got power. They say, not so. Are you guys ridiculous? Nobody in DC has any power here. Those aliens are in the custody of a foreign nation pursuant to its laws. It's in El Salvador. El Salvador is not in your district, Judge. The United States does not have custody, so there is no jurisdiction. And second, they claim aliens in criminal custody may be removed to El Salvador at some undefined point, and so therefore custody exists in this district as well. But that is just pure speculation, and that doesn't establish custody or jurisdiction. So, Judge, you lack jurisdiction to grant the relief that they seek here. Supreme Court has already said it, and logically, it follows here. But in any event, even if you think you do have jurisdiction, the JGG gangbang lawyers, they fail on the merits. The United States has and will continue to provide procedural due process. And this is, just to be clear, right? This is something they've always provided. Due process was always provided. It just wasn't enough of what the left wanted. In other words, the left would have you believe that due process is a criminal trial jury by peers with appointed lawyers to determine whether somebody's in the country illegally. Like, you want a jury trial to determine whether they're here illegally? You want a jury trial to determine whether they're actually Tren de Aragua? Are you out of your mind? They're illegals. They're not here. We're not charging them with crimes. We're just getting them out of the country because they don't have any basis to be here. Now, if you do want to charge them with crimes, if you want to incarcerate them, then indict them. Pam Bondi's doing that too. Both things are happening simultaneously. But while they're getting afuera out of here, they're getting plenty of procedural due process. We've already confirmed that. Petitioners' substantive due process rights and 5th, 6th, and 8th Amendment claims, however, are not cognizable against the United States and are baseless in any event. And petitioners' complaints with the proclamation are similarly non-justiciable. But even if they were, the president had ample basis to determine that Tren de Aragua is a foreign nation or government, that there is a predatory incursion and more. And given that, they're not going to win. And the equities also don't favor the gangbangers, as an injunction would disrupt our sensitive foreign affairs and literally keep terrorists in the United States. And as a result, this should all be denied. And here's the background. All right, Boasberg, for the second time already. You know, in March, the president issued Proclamation 10903, invoking the Alien Enemies Act, saying we're going to remove the Venezuelan nationals right out of this country. In the early hours of March 15th, the 5 named plaintiffs, here the putative class, which the Supreme Court allowed to be created, another class of Trend Day. We got 2 gangbangers that we're talking about, Tren and MS-13. Both have class actions going now. They initiated this litigation and they sought immediate injunctive relief. You can't deport us. Now, in their lawsuit, they sought habeas when they originally filed. They said we're unlawfully detained. But then they dismissed their habeas claims. Why? Because they screwed up. If they had a habeas claim bundled in with the rest of their claims, the judge would have had to dismiss all of their case and said, wrong court, gotta go file in habeas in Texas. So they stripped out the habeas claim, which is the right claim. And the judge just said, well, I'll just continue to hear the rest of the case based on the APA and Constitution and other substantive arguments, which are not allowed to be heard. Proceeded on other causes of actions. The court then issued 2 TROs preventing the removal of the named plaintiffs, so the people on the airplanes, or never got moved, right? The actual people who are party to this lawsuit are still here, and prevented all of the rest of the certified class, wrote the minute order. Now, after the DC Circuit Court of Appeals denied the government's request for a stay, saying, let us continue to do this, the government applied to the Supreme Court to vacate Boasberg's TROs. The Supreme Court granted it, said, because the aliens' claims fall within the core of a writ of habeas corpus, they must be brought in habeas. Jurisdiction lies in only one location under the law, the District of Confinement. The court further held that the aliens are entitled to notice and opportunity to be heard appropriate to the nature of the case. Right, due process. They're aliens. They're not citizens, including that they're subject to removal, which is notice, which is due process, within a reasonable time and a manner that will allow them to actually seek habeas relief in the proper venue before the removal occurs, right? So it's notice and opportunity within a reasonable time to file and to make their claim. In other words, you don't give them notice as they're getting on the airplane. Hey, you're being deported. Buckle up. See ya. That's not enough time. Got to give them 28 hours, 48 hours, and whatever the argument is. Now, some courts are saying 30 days. Other courts are appointing the ACLU. So they're just like notified. Another case, another case, another case. Dang, they got them all. Like they're just appointed attorneys. But in defiance of the Supreme Court's decision, okay, and so for all the people who constantly lecture, Trump is disobeying a Supreme Court order. He was ordered to facilitate the return of Abrego Garcia and all that stuff, which we've talked about ad nauseum. Just ask them this following question. Why is Boasberg ignoring the Supreme Court? He vacated the TROs, said you don't have jurisdiction over this case. He's still holding the case and entering and considering more preliminary injunctions. It's because the Supreme Court is not being clear. Everybody can do whatever the hell they want because they're just writing stupid opinions and not solving anything. So Trump is in total compliance with the Supreme Court. He did facilitate the release with due deference due to the executive branch. He's executing the exact due deference that he is entitled to, which is to do nothing. Now, petitioners persist in their efforts to anchor this habeas litigation outside the jurisdiction of confinement, right? So they are not in DC. How do we stay in DC? After an unsuccessful attempt at a third TRO, writes Trump, these gangbang lawyers amended their complaint to add new claims on behalf of 2 new subclasses so that this case could stay. A subclass of aliens detained at CCOT and a subclass of criminal detainees. So then they moved for new emergency injunctive relief for a 4th time. We're back here again, Boasberg scrambling to keep the case. This time, they seek an order requiring the government to facilitate the return of the putative CCOT subclass. So all the people who are already afuera gotta come back because they're a new class of people in a foreign country to the United States. They also want an order enjoining the removals of members of this subclass. Now, as Deputy Secretary Landau, writes Trump, makes clear, the members of Tren de Aragua and CCOT are being detained under the authority of El Salvador. It is a sovereign nation, in case you didn't know. There is no binding agreement between the United States and El Salvador that provides the United States with control over these individuals. You see that there. Wow. But the court, they say, you can't hear this case, Judge Boasberg. The Supreme Court already confirmed this. Now, their first innovation to try to bypass the Supreme Court's ruling is to say the United States does have custody. They say, well, you do. They're in a territory of and by agents of a separate nation. They say, well, they can say that, but it's just not the case, okay? There is no basis on which they can claim that the United States exercises any control over El Salvador. Now, to the extent the United States and the El Salvador government made a bilateral arrangement, it is not an enforceable agreement providing the United States can obtain or retain control over aliens that are imprisoned on their soil by their guards. And in any case, the burden is on them, the gangbang lawyers, not us, to make a clear showing that this court's order will likely affect the desired outcome of their habeas petition, which is release from Salvador in custody. And because they cannot do that, this court lacks both constitutional and statutory jurisdiction over the petitioners in El Salvador. You can't control what's happening in their country. Now, at the outset, the Supreme Court's own definition of custody for habeas purposes demonstrates the futility of their argument. Let's begin with the statute, they say. This applies to those held in custody under or by color of the authority of the United States. And in custody is when the United States has him in custody. Okay, it's clear, undisputed. They're in El Salvador. They're not actually within the United States physical custody. They can't even invoke constructive custody by saying, well, the imprisoning sovereign is our agent, right? Like El Salvador works for us. The United States, they say, has no control over the actions of a foreign sovereign. Now, as the courts have repeatedly confirmed here, control over detention and the detention site is key. This case is not like Boumediene versus Bush. These are the terrorist cases that we've been waiting for weeks now. Oh, here they are. Back in 2008 when Bush was in charge, where the United States did have control over the place of imprisonment, which was in Cuba. Those are the Gitmo cases. Instead, the case is closer to Johnson versus Eisentrager, which is a 1950s case. As the Supreme Court explained back then, the state's control over the prison in Germany, which were housing prisoners back then, was neither absolute nor indefinite. And the same was true in this other case in 2010, where the district court found no habeas jurisdiction exists, even though the aliens were held by the U.S. military at an Air Force base because the U.S. was merely leasing the base and did not have de facto sovereignty over it, right? So in other words, many other examples where we've handed people off different locations and the court said, oh, they're gone, nothing you can do. Here, not only does the government not have sovereignty over CCOT, but it doesn't even have a military presence or a lease at all. So that defeats habeas jurisdiction in this court, and you can't have it here. Judge, you can't hear this. Now, even more analogous is this other case, United States versus Dulles. Says there, the petitioner pled guilty to crimes while stationed in France, served a 5-year sentence in a French civilian prison. The wife petitioned for a writ of habeas corpus there, saying, release this man. The DC Circuit said, there's no jurisdiction here. We don't have control over a French prison. What are you, nuts? Get out. Likewise, in another case, same thing, Japanese. We can't control their custody. There's no custody here. So this court should avoid significantly expanding constructive custody in this novel manner. You don't have custody over prisons in France or Japan. Are you crazy? Indeed, here is even less of a reason to find the United States has control over El Salvador. El Salvador is a separate sovereign over which the United States has no control. There is no bilateral treaty between the U.S. and El Salvador over prisoners. El Salvador makes its own decisions, and any bilateral arrangement there may be between the United States and El Salvador is not an enforceable agreement that somehow allows the United States to retain degree or control over these people. Indeed, the corrective machinery here is non-judicial. The prisons are operated exclusively by the Salvadoran government, which has its own laws and procedures. And guess what, Judge? It's not for U.S. courts like you to question a separate sovereign's choices. In fact, the D.C. Circuit, above you, your boss, credited the United States Declaration, and it no longer had custody or control of Guantanamo Bay detainees transferred to Afghanistan or the Sudan. While petitioners argued that their habeas petitions were not moot due to collateral consequences, the court held that the harms were traceable to a foreign sovereign. And their response, citing these other cases, is not supportive either. Their primary evidence that the U.S. has custody comes from a handful of vague statements by a few officials that the United States is paying El Salvador to detain petitioners. In related context, public statements by officials have not been credited as evidence of the purpose behind an executive policy. Like in other cases, you don't go outside of the official policies. So you can't go and say, well, that guy said this that time on that TV show. Well, that doesn't matter. The policy is what we say it is. It's right here. Just because some weirdo from the administration, was goofing off on some show somewhere doesn't mean anything. Such limited out of context statements cannot establish that they're going to win on this. This is contrasted by a clear official declaration under oath that the United States does not have custody or control over these petitioners. You got vague statements from somebody else. Okay, whatever. Somebody's saying this on TV. But we say right here under oath in a declaration, we have no custody or control over this at all. El Salvador makes its own detention choices as a separate sovereign, and that should suffice. It's a sworn statement by the administration submitted here as Exhibit A. It says, hey, listen, I am Christopher Landau. I'm the Deputy Secretary of State, and as deputy, I do a lot. Now, I'm aware that this lawsuit has been filed on behalf of the named plaintiffs in 2 subclasses, including aliens and CCOT, seeking an order to facilitate the return of a subclass and an order enjoining the removal of more. I provide this declaration based on my personal knowledge and experience, and here's what I can tell you based on everything I know. One paragraph here. El Salvador is a sovereign, independent nation with its own domestic law and international obligations governing the detention of individuals. El Salvador makes its own sovereign decisions, including with respect to detention. Signed, Signed by Christopher Landau, Deputy Secretary of State. It's on a map here too, Judge. They should send him a map and a globe. And it's right here, point to it. And it's its own country. It's a real place. We don't control them. They have a president and people, and they vote, and they do all sorts of things down there, and they make pupusas. It's great. Check it out. So it's a real country. You should look it up, Judge. Check on Wikipedia or something. So they're referencing, right? That's alone. That's it. That's enough. Now, petitioner's position, the gangbang lawyers, is at odds with this court's interpretation of its own TRO. You, Boasberg, interpreted its TRO as stopping the government from removing members of a class or transferring them into another country's custody. The court also found probable cause. The government violated that order by not turning the airplanes back and ordered the government to purge that contempt by asserting custody of the individuals, right? The Supreme Court said, you don't have jurisdiction. Your injunctions, your TROs are vacated. The judge said, well, now you're in contempt, but you can cure the contempt by complying with my illegal vacated TROs that he had no power to order at all. So he's almost in direct contravention of the Supreme Court and saying you can purge that contempt, right, by complying, by just doing what I said. Well, I didn't have to do what you said. It was illegal. Well, do it, and you'll purge your contempt. And the Supreme Court is just sitting there, just allowing this to happen. Like, petitioners defended the court's interpretation and order on appeal, but the court's order already established that we do not have custody over these people, okay? El Salvador does, so you can appeal it all you want. If we retain custody, as they insist, then it could not have violated the court's order, nor could the government purge the contempt by asserting custody over them if it always had custody to begin with. So you can't have it both ways. This court, the United States, and even the petitioner realize the reality. We don't have custody of people in SEACOT. The separate sovereign nation of El Salvador does. That's it. The case is over. One last point related to custody, though. Even if the United States were to take steps to, quote, facilitate the release and return to the United States as they seek, they have not shown that these actions would have a substantial likelihood of effectuating their release from custody. It's their burden to show that. They haven't even attempted to show that. They present no facts or allegations that the U.S. could obtain the release just by merely asking. They say, well, just call Bukele. They say, well, what if we do? What do you think's going to happen? Who's going to release him? Well, you don't know that. What's your evidence that he's going to do that? Well, you have none. Okay, so then we don't have to make the call. They instead focus on whether the United States sent the detainees to El Salvador, which is undisputed. We know he did, and its motives for that. But they merely assume without any actual facts, it's just an assumption, right? It's not a fact, that the existence of a bilateral agreement about detainees means that the United States is their custodian, right? You have to have a contract. You paid them for something. So what? People have contracts and change things all the time, pay for stuff all the time. Doesn't mean you're in control of the thing you exchange. That is not just contrary to the realities of international affairs. It's also a failure of proof on an essential element of the irreducible constitutional minimum of standing. Now, the DC Circuit rejected a similar argument that the court might order the government to take all steps within the power to alleviate their injury because you got to have some traceability. You can't have stuff that's too speculative. Well, you just have to like fix everything. What, Judge? Specifically, you got to tell us what to do. Otherwise, we'll be out of compliance with your order because we don't know what you say. It's a due process problem for the people receiving the order. What are you telling us to do? We have no notice, so we cannot comply and will be held in contempt as a result. So you got to have specificity. This court lacks the jurisdiction because the U.S. does not have custody of them and they don't have standing for the remedy they seek. Like they say, well, there's an agreement. Well, the agreement says what we know it says. So if you say it says that we're in custody of that, you have to allege a fact. You can't just presume that. The burden is on you. You don't just get to come into court and start lobbing allegations based on assumptions, and then we have to act based on your assumptions. What is your evidence that we're in control? We say we're not in control. Our declaration is here on its face. So if you think that's a lie, you got to present evidence otherwise. This court lacks jurisdiction over the class. Now, the second innovation that the gangbang lawyers are trying to do to bypass the Supreme Court to skirt around it is to say that individuals in, quote, criminal custody may challenge their future confinement in this court. Now, that argument also fails for all the reasons that their same constructive custody argument fails, and doubly so. It's completely speculative that anyone, much less every member of the class, will be confined in SEACOT under the custody of one of the respondents in this district. Like, you can't say that that hypothesis or that hypothetical is going to come to fruition unless you're speculating. Indeed, some of the class members may be in state custody for years. A lot can change by then. And the cases they cite don't support their claims to the contrary. So the confinement and injury were wholly speculative, which is just what's happening here. And so this court lacks jurisdiction over the putative claims because they haven't articulated a clear basis for the elimination of the class. Now, the government is providing adequate due process here, telling us the petitioners, the ACLU gangbang lawyers, once again argue that they are not receiving sufficient notice and opportunity to seek habeas. That's wrong, okay? Due process is flexible and calls for such procedural protections as the situation demands. stands. It's not the same for everything all the time. Now, this is especially true when it comes to immigration and foreign affairs. The Constitution gives the political department of the government plenary authority to decide which aliens to admit and the power to set the procedures to be followed, a Supreme Court case from 2020. Now, what the Supreme Court required is this. Notice that they're subject to removal under the Act, so they get a little notice and letter, and within a reasonable time that actually allows them to seek habeas relief in the proper venue. That's it. Opportunity. Reasonable time and opportunity. It didn't say that they had to be granted a hearing before the removal. Okay? They could actually seek it if they wanted to, but it's not mandated to them. That is exactly what the government gives them, okay? They all got it. The government gives individual notice to all aliens who are detained or may be removed under the proclamation, who have been determined to be members of TREN and are cited for removal. The notice is provided in a language that they can actually read, generally through an interpreter. The alien is also informed that they can make a call to anyone they choose, including a lawyer. Now, once they get the notice, they have at least 12 hours, to express an intent to file a habeas petition. After that, they have at least 24 hours to file a petition. Now, in practice, they often receive more time, as they can file at any time prior to their removal. So it's like they're sitting in custody, they are working with lawyers, they're already working on this stuff, then they get notice, and then they get 12 hours, just let me know you're going to do it, and then after that, okay, here's a lawyer, find a lawyer, get it filed. Generally, once a habeas petition is filed, the alien will not be removed until the petition is adjudicated. Now, given the serious national security interests at stake in removing members of a terrorist organization, that is more than sufficient due process. Now, in fact, courts have rejected due process challenges to the Alien Enemies Act and removal procedures, including a case without a hearing, saying, in this case, called Watkins, there was no hearing before removal. And I said that was fine. The ability to seek a full habeas adjudication is even greater here than it was in that case. We're giving him more protection than the Second Circuit case. And the amount of notice provided to seek such habeas relief has been deemed sufficient in analogous contexts as well. It says, take expedited removal under the Illegal Immigration Reform and Immigration Responsibility Act back in 1996. The entire purpose of the act was to substantially shorten and speed up the removal process. We got like 20 million people we got to work through here and have not shown that they were in the country illegally. They got to go. Here's how it worked. If an immigration officer determines that an alien is inadmissible without valid documents, they shall order the alien removed. That's it. One officer, no valid entry documents, without further hearing or review, unless the alien indicates either an intention to apply for asylum or a fear of persecution. Now, even if the individual claims asylum or fear, the process is scarcely more involved because the immigration officer can quickly deny the claim. Oh yeah, no, you're not fearful of anything. Yes, we know. Yes, I know you're scared. Papusas, attack, gangs, got it. In fact, Congress was explicit on how fast this process was supposed to be. They wrote this down. They said, review shall be conducted as expeditiously as possible, to the maximum extent practicable within 24 hours, but in no case later than 7 days after the date of determination under the subclause. And they continue, telling us the DC Circuit has held that is sufficient. We see no reason to disturb that prior analysis, and that was because the Supreme Court has been clear that the power to expel or exclude aliens is a fundamental sovereign attribute exercised by the government's political departments, largely immune from judicial control. That happens here. Much like the Alien Enemies Act, the executive branch is given sole and unreviewable discretion to determine who is subject to expedited removal. So if 24 hours for someone who may have resided in the United States for 2 years is sufficient to satisfy due process in a prior case from 2023, then it surely is sufficient for that category of persons who the president, commander-in-chief, has determined to be enemies in the United States. Okay, so if some person who's living here, normally, let's say, without being a terrorist is identified, 24 hours gone. So if it's a gangbanger, 12 hours or 24 hours, let's say 12 plus the 24 is plenty. It would be perverse to hold otherwise, in fact. If the government provides at most 24 hours of notice, there's no due process issue at all. And as noted, in practice, aliens receive much more time anyways. But then the ACLU and the other gangbang lawyers who are in all these cases, they point to a district court order and to practices during World War II. They say, oh no, we got to have like 30 days. A TRO from another district that is being appealed right now does not justify the sweeping nationwide one-size-fits-all order here. Due process is flexible. It's in our case law all over the place. Now, as to 30 days provided in World War II for the Germans, the DC Circuit noted that that proclamation was less than the scope of the act, and the procedures reflected the restraint with which the AG has exercised his authority. In addition, more time was required to provide notice, communicate, file claims, hold hearings. World War II, they didn't have the internet. Now, given the generous procedures provided provided at the time, the process in World War II hardly marks the minimum of due process, right? So in other words, in that case where they gave 30 days, they're like, well, they were just being exceedingly generous, and they even noted that. Exercise with his authority, a lot of restraint there. Now, regardless, many of the named petitioners here have received sufficient notice and due process. In fact, one person who's a party to this lawsuit, called TCI, the representative for the criminal custody subclass, has been in custody since January 2024. He had notice of his removability for weeks, so why is he even here? The original named petitioners have been in custody for months. They've already filed habeas petitions that are and will be adjudicated. Now, this is likely true of the other class members who have yet to be removed as well, which illustrates why a class certification here is totally improper. And the Supreme Court has stayed removal in the Northern District of Texas for 2 weeks, offering more than enough time to seek habeas. By the time that they can be removed, they may have had more time than even their position demands. Like, they have months, not just 30 days. In addition, even those who have already been removed had some notice prior to their removal. But regardless, the Supreme Court said after the date of this order, so we don't need to go backwards and pull people back out. Now, what we're saying to you, Judge Boasberg, is we are not illegally detaining or punishing any of these aliens after removal. Now, as has been made clear, the government of the United States does not have custody over anyone in El Salvador. So the government cannot be detaining or punishing aliens that it has removed from our custody. When they're in CCOT, we're not punishing them. That's El Salvador. They're theirs. They assert that detaining them after removal violates the AEA. Like, you got to just drop them off there, but you can't put them in a cell, and constitutes criminal punishment in violation of substantive due process, right? So now they're making another claim. Well, practically what you're doing is violating our substantive due process, because you're essentially charging us with a whole new crime by deporting us and putting us into custody in our home countries or in El Salvador. This theory remains contrary to this court's contempt order, which found probable cause that the government transferred the class members into another country's custody, right? In other words, the judge said, hello, that we sent them into their custody. So how can we be punishing them and violating their substantive due process, we, the US government, if they're in another government's custody? We can't be doing that. So obviously it's logically inconsistent. Just read the words. That order acknowledges the aliens were transferred. So even if the government had custody for habeas purposes, which we don't, it could not control how El Salvador treats its detainees. And we cannot raise or sustain such claims in any events either. Now, we get to some substantive due process. They say that the gang lawyers claim that detaining them after removal is criminal punishment in violation of substantive due process, right? They weren't charged with crimes, they were just removed. If they're charged with a crime, they go through the Article 3 courts. Again, the government doesn't have custody of them. We're not responsible for what El Salvador does with them. Even if the government had constructive custody over them for habeas purposes, which we don't, that would not mean it had control over the conditions in El Salvador. Like, Kilmark was El Salvadorian. If they're being punished, that's their problem in El Salvador. It's a separate sovereign. Talk to them. Courts cannot remedy the fact that a foreign sovereign is exercising its legitimate discretion. So conduct in El Salvador cannot be attributed to us, so leave us alone. Now, in any event, even if the United States did have some control, courts must be reluctant to expand the concept of substantive due process. For example, even in DC, see, this is what I was explaining, I think a couple of weeks ago. I was saying they're going to have a hard time saying that you got to give these illegals a bunch of rights, because they already said the terrorists don't get a bunch of rights in the terrorist cases during the global war on terror. And like, that case law was aggressive based on the Patriot Act and everything. And we're all sitting here going, uh-oh, they're going after the terrorists. They're kind of coming after us. Saying, yeah, even the DC Circuit said, no, they can't bring their claims under substantive due process back there. And CCOT is the same. Here, it's not even like at Guantanamo. The U.S. not only lacks de facto sovereignty over CCOT, but unlike Bagram, it does not even have a lease or military presence there. So CCOT is operated by El Salvador. Detainees cannot bring claims there against the United States, even if it had custody there, right? They couldn't sue when we had some level of control in other cases. We have no control here, so they definitely cannot sue. And even if they could raise these claims, they can't show that they're going to win. To show that we intend to punish them, they're relying on vague statements that are not policy. Those statements don't demonstrate the purpose of punishing anyone. Even statements by the president don't establish a particular purpose behind the policy. The legitimate non-punitive purpose is public safety. We want the gangbangers out of here, and that's justification enough. Now, they conclude that confinement is excessive. They say, well, CCOT's different. They say, well, we're detaining them here. Okay, we'll just detain them down in CCOT and give them to them. Yeah, but that's excessive, they say. It's too harmful. They make them duck their heads when they run. They say, well, we don't even know what that means. It's excessive? What? If they are raising an excessive force claim under Kingsley, well, they haven't put that in their document. That's hilarious. They're like, well, we don't even know what that means. means. They know they're not raising an excessive force claim, but that's like a little jab there. If you're raising an excessive force claim, you didn't include it. If, as you suggest, this is a deliberate indifference claim, well, you got to establish that. We don't even know what you're saying. And they haven't submitted anything that's showing it's punitive, and so that claim fails. They cannot maintain any substantive due process claims on that basis either. Now, they also bring some constitutional claims, Fifth, Sixth Amendment arguments, saying, oh, this is basically criminal, right? Like, you're basically prosecuting us, since CCOT is like torture, and the Eighth Amendment. You're violating our Eighth Amendment rights as illegal alien terrorists in your country. These, again, rest on intent to punish, and they fail for the same reasons. We don't have custody over them, so we're not punishing them, first of all. And since they're not here, we can't hear their Eighth Amendment claims either. Now, even if the government had custody, which it doesn't, what El Salvador does is within their prisons. If knowledge that a foreign nation seeking extradition might violate U.S. standards of due process, it could disrupt treaties and more, and so courts should avoid the involvement in these areas that are outside of its scope. They talk about the Convention Against Torture and other claims, but this continues. They also argue that the Alien Enemies Act does not authorize detention after removal, right? You can just drop them off, but they can't be contained there so that they can just come back across the border and invade a second time. Again, they're not in our custody, but we don't have control over them or what they do, and they can't bring a claim in this court anyways. You can't review this proclamation. It's a separation of powers problem. For more than a century, you've held that the AEA is not a proper subject for judicial scrutiny, and the Supreme Court has already said in this case, the AEA largely precludes judicial review. Have already said that in this before. The Ludecky case doesn't support their view that a judge can override a decision by the president, and their citations don't support that claim either. The Supreme Court has also held that the political question doctrine is a function of the separation of powers, and what the president decides goes to the core of the separation of powers, and the courts cannot interfere in that. We've already talked about how this is an invasion and a predatory incursion. The president has a textual commitment to prevent that from happening, and so the AEA proclamations are conclusive and they're preclusive. You can't question them and you can't challenge and subordinate them. All of the courts have no role to play. The other statutes don't supersede the Alien Enemies Act, and other statutory of withholding or removal claims, nothing here constrains the president's actions under Title 50. The individuals subject to removal are barred from asylum and they're barred from withholding of removal. Same thing with Kilmar. Once they invoke the Alien Enemies Act, statutorily, he was no longer eligible for withholding of removal by operation of law. The Attorney General said so, overrode the judge. So he could have been sent to El Salvador for two reasons. One, the order said Guatemala, and two, the withholding of removal for El Salvador, even if you think it was a scrivener's error because you can't read, then what you'll know is that he could have been sent to El Salvador on that basis as well, because there was no withholding of removal there. So either way, he's where he needs to be. Now, asylum is a discretionary form of relief, and eligibility for this is foreclosed. Pam Bondi, by operation of law, foreclosed it. The AEA disallows for relief for covered enemy aliens. You cannot invoke withholding of removal when you're a terrorist. Sorry, we give it to good people, not terrorists. Likewise, aliens subject to removal under the AEA would not be eligible for statutory withholding of removal when the president says there are reasonable grounds to believe it's a national security risk. And we looked up that U.S. code. We even put it at the watcherlodge.com research file section. Nor may this court review our claims under the Convention Against Torture either. And moreover, there is no direct conflict between our obligations and sending people to CCOT. And we satisfy all of the statutory prerequisites here. This is an invasion. Trump has declared it accordingly. At minimum, it's a predatory incursion. There's raids and hostilities like occurred in Mexico in 1945. And invasion and predatory incursion don't necessarily entail military actions. Just look it up in a dictionary. An invasion is a hostile entrance into a country, and declared war is not necessary either. The statute gives the president the power to act even outside a declared war, as it must, because we already know how to declare war. We don't need the AEA to declare war or to give us war powers. That's already in the Constitution. The United States enemies do not invariably announce their intent to attack, merely consider the surprise attack by the Japanese or Al-Qaeda on 9/11. The president is acting on reports and public intelligence, must have the ability to restrain and remove aliens not only under acts of war. The founders realized this, Boasberg, which is why they permitted the president to act upon something less than armed conflict between the militaries. It's called an invasion. It's called a predatory incursion. It's not an act of war. It's something less. To give the president the ability to act in emergencies. Here, there is no question that the gangbanger TDAs have effected entries into the United States contrary to the law, committing violent crimes, conducting criminal businesses, trafficking in substances and people. These are are grave problems that affect the entirety of the entire nation, and the president has declared it accordingly. And the proclamation also says that they're connected to Venezuela and the government via the Maduro regime. The Cartel de los Soles coordinates and relies on TDA to carry out its illegal narcotics trafficking. Bunch of sources in there, but in all events, TREN acts like the governing authority in areas where it operates. It's in functional control, and there are other arguments saying, well, TREN de Aragua is not a nation, so you can't do anything against them. Don't match the rules under the AEA. And they say we should have a voluntary departure, right? Well, you got to give them an opportunity to self-deport. Well, they had that opportunity. They didn't take it. Petitioners haven't established irreparable harm, and the balance of the equities favor the government. And so in conclusion, they write, the motion for a preliminary injunction to you, Judge Boasberg, should be denied. Signed here by Drew Ensign and the rest of the team on this very important case in Judge Boasberg's courtroom.